We have an update on our case against the FBI and their relationship with the New York Times. A federal judge has just issued an order in our case involving a FOIA request for information between the FBI and the New York Times on the subject of the raid against myself involving Ashley Biden's diary. Now, just to take a step back for a minute, the New York Times should be investigating the FBI, but oftentimes they act in concert with them and the Department of Justice. As you remember, the government also appears to have leaked the contents of the search warrant against me to the New York Times when the FBI raided my home. Shortly after the execution of the warrant, I received this message from Mike Schmidt, a New York Times reporter. Now, as you recall, Mike Schmidt is the one who went on a curse-laden rant about the, quote, stupid f***ing diary, unquote, months later after my colleague covertly recorded Schmidt trying to recruit my colleague as a source.
I'm just trying to figure out what happened with the stupid fucking diary. I got a pile of shit on a table, right? Of a bunch of shit that happened around this PV stuff, right? I'm just some dude out there with a blank notepad, crazy world, trying to figure out what the f***'s going on. Now you got some asshole from the New York Times on the phone with you, who's trying to, you know, whatever. And you're like, well, f*** this. Why am I gonna trust this guy? Why am I gonna talk to this guy?
During that raid against myself, Spencer Meads, and Eric Cochran, the FBI grabbed extensive work product, journalistic notes, and attorney-client communications between myself and my attorney, Ben Barr, who's still my attorney. Then the New York Times published them on their website. Now, this sentence is from a New York Times article by Mark Mazzetti and Adam Goldman. It's worded in a very twisted, contorted, funny way, a point that comedian Jimmy Dore pointed out when he read the article.
So there's the headline. It says, documents show how the conservative group worked with lawyers to gauge how far its deceptive reporting practices could go before running afoul of federal laws. You know, another way to say that is they consulted with a lawyer to make sure everything they were doing was legal. That's another way to say that.
I also confronted Mark Mazzetti at the Times about the absurdity of New York Times national security reporters working in symbiosis with the national security state. Why is it that the New York Times works in concert with the FBI? Why not investigate the FBI? Why work in a symbiotic relationship with federal agents? And I also confronted Adam Goldman, who appears to have been in hiding for the last couple of years, worried about me finding him, but find him we did. I also asked Mark Mazzetti if the trophies he's been pursuing, Pulitzer Prizes and such, have corrupted his motivation. This was the article you wrote. See, it says, transporting material across state lines. So, should the FBI raid your family's home for transporting my stolen documents across state lines? The National Review reported on all of this. What has been leaked to the Times and what the Times has editorially chosen to publish is not confined to the Biden diary investigation. The Times is heedless of Veritas' right to counsel and the constitutionally based confidentiality of its attorney-client communications. Given how the Times would react, or the shoe on the other foot, which is hardly inconceivable, this is shocking. The federal judge in our case, Annalisa Torres, an Obama appointee, abruptly ordered the government to stop extracting materials from our phones, and the Justice Department is running roughshod over our right to counsel. Then a state judge in New York State ordered the New York Times to surrender the attorney-client privilege memos they obtained. This is some coverage from The Guardian just around Christmas 2 years ago. The New York Times publisher Arthur Schulzberger was aghast, decried the ruling as an attack on press freedom and alarming for, quote, anybody concerned about the dangers of government overreach into what the public can and cannot know. Now, that's ironic. I would think government overreach involves taking a battering ram to our door, seizing our stuff, and then leaking it. As National Review pointed out, what if federal prosecutors had the temerity to seek and manage to obtain court-authorized search warrants against New York Times reporters on the allegation that the paper was in possession of evidence of a crime, perhaps even that some of its reporters were somehow complicit in the crime? The screams of bloody murder from West 40th Street, that's the New York Times building, and by the way, I posed as Santa Claus a year ago and asked for alms for the poor, would be audible across America. Now, those government leaks to the press are all the more remarkable in light of the fact of the cautionary language the U.S. Attorney's Office included with its grand jury subpoena, and that said, quote, "The government hereby requests that you voluntarily refrain from disclosing the existence of the subpoena to any third party." Which takes us all to today. A federal judge just last week ruled in favor of the Justice Department and the FBI and against Judicial Watch's lawsuit filed on our behalf to obtain information about the raid, specifically communications between the New York Times and the FBI. One of my next-door neighbor's statements to the New York Times seems to have convinced the judge that there was no leak at all. Now, the federal judge makes reference in his opinion that the New York Times had contact with a neighbor of O'Keefe regarding the execution of the search warrant. Moreover, as articles cited by plaintiff make clear, O'Keefe himself spoke directly to the New York Times regarding the FBI investigation, including even before the search warrant was executed at his residence. Now, that's not entirely the whole story. We published a video the afternoon of November 5th, which was the day after my two colleagues were raided, but it was the day before the raid against my home. The judge also writes, plaintiff's premise that the FBI was the source for the New York Times' reporting ignores the more obvious cited sources for the reported information, including a neighbor at the location which was targeted in the search warrant. Mike Schmidt at the New York Times had sent me an email earlier in the morning on November 5th at 8:52 a.m. with a lot of substance about the search warrants and all this case. That was before I went public in my video on the 5th in the afternoon. You can see the date stamp there on YouTube. This was published hours after Schmidt had any information specifically about the grand jury subpoena and the substance of the search warrant. So who gave all that information to Mike Schmidt, which he had in his email, and you can see his email right here? How did he know all of this? The neighbors did not tell him all this because all the neighbors saw was pounding on the door. Let's look at what the neighbors told the New York Times. Quote, "They asked for James, banging on the door, open up the door. A teacher said, the agent said, open up, FBI. I ran to the door, looked out, and there were jackets like out of a movie." It doesn't seem like the neighbors would know the secret grand jury subpoena and search warrant information. The judge also writes, in short, that our purely speculative claims about the existence and discoverability of documents through alternative search terms does not overcome the presumption of good faith to which the FBI's conclusion regarding the adequacy of a search is entitled. Presumption of good faith. How is any of this undertaken in good faith? First of all, your boss, the Attorney General, expressly forbids forcible seizure of reporters' notes. All of this is in bad faith and likely illegal and unconstitutional in every conceivable way. In fact, in the motions back and forth on this FOIA request and in Judicial Watch's opposition to the Department of Justice's motion for summary judgment, it was pointed out that the FBI did not search text messages and instant messages for records, which should be public. The judge argued that unless we can prove the existence of those messages, they're under no obligation to search for them, which is how the FOIA system works. I'm not sure that it should work that way. You have to basically prove the records exist in order for the government to hand them to you. But text messages are how the New York Times communicates with its sources at the Department of Justice. It's not through an email, which can be discovered, but through means by which it cannot be discovered. Text messages, like the text message that Mike Schmidt from the New York Times sent to me. The New York Times has been trying to take me out for years. I finally had the proof, the smoking gun, that the FBI and DOJ are working in tandem with certain journalists and media outlets, but I was denied access to critical records by a judge in the Southern District of New York. Imagine that, and understand that the only way for us to get the information is through covert, undercover, investigative journalism. That's why we do what we do, and we're going to do a lot more of it. Stay tuned. Mike Schmidt, Adam Goldman, Mark Mazzetti, and Merrick Garland.